Welcome to the Court of History. I'm Sidney Blumenthal. I'm here with my colleague, Sean Wilentz from Princeton University, subscribed to Legal AF. We're here with Lisa Graves, the author of a new book on the Supreme Court and John Roberts called Without Precedent, How Chief Justice Roberts and His Accomplices Rewrote the Constitution and Dismantled Our Rights. Lisa was the chief counsel for nominations on the Senate Judiciary Committee. She was Deputy Assistant Attorney General. She is the Executive Director of True North Research, President of the Board of the Center for Media and Democracy. In part one, we discussed the myth of John Roberts as an institutionalist and the court takeover. And we'd like to continue that. For those who have not heard part one, I urge you to watch that. Now we will pick up with John Roberts leading the Supreme Court to cover up what becomes the coup of January 6th. First of all, what he does to create the presidential immunity decision.
Yes, this is, I think, perhaps the worst decision ever issued by the Supreme Court, although Dred Scott still holds that role in history because it propelled us into the Civil War. But this decision in Trump versus United States dismantles a core component of the United States in a way that is different than what happened in Dred Scott. What John Roberts has done is knock down the central pillar of the founding of America, which is basically founded on no kings, on not having a president be a king. And in fact, the Constitution in two places expressly says that the job of the president, of the leader of the executive branch, is to faithfully execute the law, to act faithfully toward our constitutional laws. And what John Roberts did was orchestrate a decision, a partisan decision by the 6 Republican appointees to the court, including himself, that in essence pardoned Trump, that exonerated him, that said that he could not be held liable in criminal court for his prior actions, and that he couldn't going forward. And he sent a signal to a subset of the American people that Trump did no wrong and could do no wrong, and that the prosecutions of him were illegitimate. In fact, those prosecutions were well grounded in law and the Constitution, which also describes how presidents can be impeached for high crimes and misdemeanors. And even Mitch McConnell, the then Republican leader of the United States Senate, in voting against that second impeachment, improvidently, outrageously voting against it, conceded, as the other Republicans who also voted against it conceded, that of course Donald Trump could be tried for his crimes surrounding January 6th. But not just that. That's not the only thing that John Roberts did. The other thing that he did was to move heaven and earth to block Colorado from keeping Trump off the ballot. In that case, the court acted rapidly in order to stop a decision by the Colorado Supreme Court and lower courts that, of course, under the 14th Amendment, Donald Trump was barred for engaging in insurrection, for fomenting an insurrection. But John Roberts worked to create basically a 5-4 ruling that he didn't even sign, that blocked Colorado from keeping Trump off the ballot. And
let's go back to the signing for a minute, because he assigned it to Justice Alito to write. And there were 2 justices on the Supreme Court who should have recused themselves because of conflicts of interest involving January 6th.
January 6th, yeah.
Yes, that's right. So there's the third decision involving people who were charged with crimes people were charged with crimes for their actions, their violent actions during the 6th. Yes.
The Fisher decision.
The Fisher decision. That's right. And so what happened was there were 2 justices on the Supreme Court who were clearly conflicted, who under the federal recusal statute should have recused themselves. And one of them was Clarence Thomas, whose wife, there's ample documentation of her role, her text messages to Mark Meadows trying to stop the recount, her actual outreach to legislators in Wisconsin and Arizona to try to get fake electors appointed. There's no way Clarence Thomas should have been near that case. But also, there's no way Alito should have been allowed to sit on that case after a flag aligned with the insurrection, the upside down American flag, was hoisted over his home for weeks after January 6th. So both of them had significant conflicts that any reasonable person would believe they would not be fair, could not hear those cases fairly. But John Roberts let them sit on the cases. And as you point out, Sidney, in one of the cases, Roberts had assigned Alito to write the opinion. But then after the news broke about the January 6th sympathizing flag hoisting, Roberts took that assignment away and wrote the decision himself. So he didn't ask Alito to recuse or demand that Alito recuse, this supposed institutionalist defender of the court. He let him sit on that case and participate in the arguments and participate in the drafting, in essence, even though he knew that he had an obvious conflict. And Roberts wrote that decision. But Roberts, beyond that, had orchestrated that whole ruling by taking the case up from the DC Circuit, a well-reasoned, well-grounded opinion saying, of course, the president doesn't have this wide immunity for so-called official acts. That's contrary to our entire history. And Roberts moved everything he could to make sure that Donald Trump would not face a criminal trial before the 2024 election, and that, in fact, if he returned to power, he would have even more power than he had before, and more power than any president has ever had.
In direct contradiction, as you say, to not only the spirit but the actual letter of the Constitution of the United States.
Yeah. So we begin with John Roberts working in Bush v. Gore to give the presidency on a Supreme Court decision 5-4 to George W. Bush, which elevates him. And then he, as Chief Justice, is an expert at delaying the process when he wants to on the January 6th case and expediting it when he wants to make sure that Trump is on the ballot, and acts in a transparently partisan way, and also does not force the recusal of two justices who are clearly conflicted out.
Yeah, and when you look at it from that perspective, what you see is John Roberts' devotion, not to the presidency, because we saw how he behaved when Biden was president and worked in all sorts of ways to block signature initiatives of Joe Biden and before him, Barack Obama, in terms of the Clean Power Plan, for example. But when there's a Republican president, there's no impediment that John Roberts works to aid Republican presidents, Bush and Trump, and in this case has done so in a way that basically made John Roberts the kingmaker for Donald Trump.
Yeah. So the Supreme Court under Roberts over the last few months has used what's called the shadow docket to issue, I hesitate to call them decisions, but rulings that provide no decisions, no reasoning, no opinions, that allow fait accompli on the part of Trump to operate on the basis of his illegitimate and illegal emergency declarations. And now the court is back. And so, and we are also facing a crisis over voting rights. Trump has talked about invoking the Insurrection Act. Governor J.B. Pritzker of Illinois has said he wants to use it to intimidate voters leading into the 2026 election and possibly use it to seize ballot boxes. And we have a voting rights case coming up involving the House. It comes from Louisiana. What can we expect from John Roberts here?
I don't think we can expect John Roberts to be anything other than the partisan that he has been. I don't think that he will do anything to stand up to Trump in any significant way. And in fact, what we've seen this year, as you point out, Sidney, is edict after edict by this court overturning well-reasoned decisions by lower court judges that Trump's actions have violated the law, that the facts prove it, that the Trump administration is behaving contrary to the Constitution, to statutes, to regulations, to contracts, and to longstanding legal precedents. But what Roberts and his fellow partisan Republicans on the Supreme Court have done is wave those laws away, without even giving the reasoning for doing so. And now we're going to see them spool out the purported reasoning, the pretext for allowing Trump these extraordinary powers. There may be one or two times where they stop Trump. I doubt it. I think what's going to happen this term is we're going to see in full bloom that the mask is off. The mask has fallen from this court, and it is going to be doing everything it can to try to rationalize whatever Donald Trump wants.
Yeah. Sean and Lisa, could you both reflect on the post-constitutional moment we're in? Have we ever been here before? Yeah. And how do we navigate it? Sean?
No, I mean, Lisa made a very good point in saying that in many ways, Trump v. U.S. was an even more, what should we say, dramatically unpatriotic, unconstitutional violation than even the Dred Scott decision. I mean, the Dred Scott decision had obiter dicta saying that blacks were not citizens. It did a lot of different things, but this has actually completely undone the American Revolution, as far as I can see. I mean, the American Revolution was fought in part for independence, but also to overthrow a monarchical order that was in power in what was going to become the United States. The United States was rejecting. The United States was going to be a republic. Trump v. U.S., basically, that decision came as close as you can to undoing that revolution. And when people say no kings and so forth, I mean, it's a slogan that has, but the fact is that is exactly what that decision did. So, we're not talking now about, Dred Scott may no longer be the measure for how bad a Supreme Court can be, how much in violation of the U.S. Constitution the Supreme Court can run. And that's my view of it.
I agree with you, Sean. And also, when you think of the people that Trump has surrounded himself with in the second administration, it includes people like Russell Vought, who are talking about a post-constitutional regime. Right. And that's saying the quiet part out loud.
Lisa Graves, thank you very much for appearing on the Court of History. Lisa is the author of Without Precedent, an essential book to understand the moment that we're in and the role of the Supreme Court, and particularly John Roberts. On behalf of Sean Wilentz of Princeton and myself, the court is adjourned, and don't forget to subscribe to Legal AF.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.